Hello, this is D, and I'm back with another video. Now, the FTC versus Microsoft case is over. Both sides had their closing arguments yesterday. Now it's up for Judge Corley to decide on the ruling. Now, I gotta be honest with you guys, I do believe that Microsoft really won this case. The FTC, they didn't prove their points, but a lot of people seem to be confused, and there's some people that still don't believe that this deal is going through. I don't know what case they watched, but the hearing, we could see which way it was going because of the questions that Judge Corley was asking the FTC, and also because of the answers that the FTC was unable to give the judge. There is a burden here on the FTC to prove their case, and the judge pointed out that there's lots of components to this deal that are actually pro-consumer, that will allow the consumer to have more options, that will be better for other companies, such as Nintendo being able to offer this game to their customers, with Nvidia being allowed to stream these games on the cloud, opening up for more customers. Basically, when this deal goes through, more people will be able to play Call of Duty than before the deal, because Bobby Koch is not on the same wavelength as Microsoft. He doesn't want to put his services on some of these cloud providers. The numbers from yesterday's case just didn't make sense. The judge kept asking over and over again how they came to that 20%. And when you looked at the papers, or I should say their calculations, really it was just a 5.5% market shift, which is not incentive enough for Microsoft to remove Call of Duty from the PlayStation. We've seen all the numbers, we know how much Call of Duty does. It makes a lot of money on the PlayStation. Microsoft is not going to remove it. They need that revenue. In fact, they've said that. You see their financial documents stating that. Satya Nadella said it wouldn't make any financial sense to remove it from the PlayStation. Phil Spencer said the same. They both swore under oath that they would not remove this game from the PlayStation. So it's really Sony here that is the problem. And the judge pointed that out yesterday quite a few times. She had to actually say to the FTC, this is about the consumers. It's not about Sony. Because they kept mentioning Sony time after time after time. At one point when she was asking about the 20%, he pointed to Jim Ryan. It was ridiculous. The representation in court was horrible. It was pathetic. And we went through that in yesterday's video, so if you want to know all the details on that, just click on that video. Today we're going to talk about the future and what's going to happen with this merger. Now, a lot of people are confused because the judge said that the ruling is going to be sealed. So they're like, are we going to know? Are we going to find out about it? Yes, we're going to find out if this preliminary injunction was granted to the FTC or if it was denied, because the parties will come out and they'll announce this. We're just not going to know how she came to that ruling because it's going to be sealed. The government will know, Microsoft will know. I did miss one detail in yesterday's video, and I was kind of annoyed that I missed it, and that's that Canada jumped into the chat. They actually sent documents to the court stating that they spoke to Microsoft before, so Microsoft's recounting of it in the courts is inaccurate. That they said that it would cause harm and the lessening of competition. Yet Canada's opportunity to block the deal, to object to it, is over. The time ran out. They actually cannot block the deal. So I found the timing kind of weird. But then when you look at what also happened yesterday, the CMA filed court documents trying to delay their case until October, and it was denied, which is definitely a win for Microsoft. And it also shows that the UK means business. They want to get to the bottom of this. And if this preliminary injunction is granted, then the deal is dead. However, when the judge, and I do believe that the judge will rule in Microsoft's favor, when she denies the FTC's request, Microsoft can close the deal. And I think at that time, they're going to have a huge advantage in their negotiation. They'll be able to talk to the CMA and perhaps hash out a deal. Because to my knowledge, the CMA watches closely what the FTC does. And if the FTC was denied their preliminary injunction, it's not going to look good for the CMA, especially on their cloud merits. The tribunal is going to be looking at all of the information from the trial, and it's going to be put into consideration with the tribunal's own ruling. Now let's look at what they filed. Now, the denial included language that suggested that the CMA needed more time to prepare its final order of the transaction after issuing its brief interim order blocking of Activision's deal. Now, they cited concerns about cloud gaming, and the main hearing appeal is set for July 28th, with an estimate of 6 days of length in trial. It is suggested that the CMA has much other work to do. Great deal of time is being spent by the CMA preparing for the final order consequent of the decision, according to the appeal tribunal filing. Investors are focusing on the language of possibility that Microsoft could have offered concessions in the comment period, which may allow some leeway for Microsoft to close the deal. CNBC's David Faber said Friday, citing people who are scrutinizing the court filings, it may be point to some difference between the interim and final order and Microsoft's efforts to get it changed, giving it the leeway to perhaps even close the transaction while they still await for the Competition Appeal Tribunal. So this is just not my opinion. These are experts in this division. I'll be honest, I don't know all of the legal proceedings. I'm reading stuff and I'm learning, and I rely on a lot of the information from more reputable sites, from people that have a lot more knowledge on dealing with cases like this. And they think that this would benefit Microsoft, especially if the preliminary injunction is not granted. Now let's go over to Foss Patents. So we're going to skim through some of the highlights. Now he goes, yesterday's closing arguments in the Federal Trade Commission, Microsoft and Activision Blizzard was lively. Now Judge Jacqueline Scott Curley of the United States District Court Attorney District had interesting and challenging questions for both parties, plus a great sense of humor. However, a litigation is not a talk show. In a talk show, there can be multiple winners, and here the outcome will be binary. The merger won't be blocked, and that's what I expect to happen. Or it would be. While Judge Corley could hardly have done more to ensure a level playing field in her courtroom, the legal framework is highly unfavorable for the FTC. It has multiple hurdles to overcome, any single one of which can be dispositive, single-handedly triggering the denial of the motion. So they got to prove multiple fronts here, and they came with a lot of things. They came with the cloud, they came with different reasons for the cloud, they came with different reasons for the consoles. And in court yesterday, Microsoft's lawyers pointed out that some of the stuff or some of the tests that the FTC is doing are for a horizontal merger. This is a vertical merger. And also, vertical mergers rarely come up in the courts like this. And to my knowledge, they haven't been blocked. So I don't know what the FTC is doing here. Like I said in yesterday's video, they seem really not well prepared. They seemed incompetent. They were grasping for straws the whole hearing. They didn't have anything that was concrete. Now, the last day, they did a little bit better with the cloud, but still they didn't prove their point because the cloud market, many people testified that it's not a thing. It's very small and minute. And although it has the potential to be huge, it's not there yet. And nobody knows when it's going to get there. And nobody knows what's going to trigger that. And because of that, you can't block Microsoft for attempting to try to make the cloud successful. This is what breeds competition. If you don't like that, go out and compete. Find a way to enter into the cloud market, especially in the beginning stages when it's wide open. Now, he goes on to say the parties will make another filing on Monday about the admission of exhibits. I believe July 5th and 6th are most likely the days for a decision by Judge Corley. She is free to rule at any time of the day, any day of the week, but it would make sense for her to enter order very late by her local time, just to be safely outside trading hours. Her initial order will be sealed as it will take some time to sort out all the redactions, but the result will show up on the docket, and it's going to be a denied of a merger block that the FTC is seeking. In a way, the FTC theoretically had multiple bites at the apple. All in all, the FTC proposed 5 different antitrust markets and of its theories of harm, vertical foreclosure. Succeeded with respect to any of them, the deal would be blocked. So practically there are 5 theories of harm in case, but we can simplify the part based on how things went on in the hearing. As I explained on Twitter, the FTC console market theory of harm is dead in the water. Those are theoretically 2 theories of harm, one for a narrow high-performance video game console market and one for a slightly broader one that includes Nintendo. It would take the inclusion of gaming PCs, and I agree with Judge Corley that in a foreclosure context, the fact that many people already have a PC on which to run most of their relevant games cannot be ignored. To defeat the console theories in the market definition stage, but there are plenty of other problems anyway. The FTC claimed yesterday that it was about protecting consumers, not Sony, but that is just a lip service to its mission of protecting American consumers. On several occasions, the FTC's incompetence with respect to how the gaming business works was on full display. Yesterday, the FTC discredited itself, particularly when one of its lawyers talked about the hypothetical scenario of a partial foreclosure in which there would be a unique game element, such as a character that would be available only on the Xbox version. Now, I can't make this stuff up. Sony just released an exclusive skin pack for Call of Duty. that is not going to be on the Xbox. And the judge was aware of this because, well, not this instance, but the judge was aware of Sony's practices because in court, when the FTC brought it up, she said, like Sony does, like Sony takes money to delay it, for it to be on their console first, for them to get, certain skins, etc. The judge is aware of this. So the FTC is making an argument that Microsoft will put a skin on their console that'll be advantage to them when Sony does that. And that's just one example of the FTC falling flat on their face. Your own testimony is contradicting. It makes no sense. You're upset that Microsoft can put an exclusive skin on their console for Call of Duty when Sony does that currently. So you are defending Sony. You're defending their interests because this is something that's commonly done. And Microsoft has said they don't like this practice, but they have to compete, and this is how this market is. So I'll leave a link in the description down below. He goes through a host of reasons why the FTC is not going to be granted this injunction. The stuff that they have to prove, it's a lot. The market definition that they were trying to prove on cloud gaming, how? It doesn't really exist. It's a very small market. Microsoft's own data shows that their consumers barely use the service. We have other providers coming out here and saying that it's not a big deal right now. Nobody's really using the service. It has the potential to grow and be big, but currently it is not a market. So what harm can Microsoft do to a market that doesn't really exist yet? Makes no sense. The FTC also had to show an incentive for foreclosure. And this is where Call of Duty came into play. And the judge, she was not buying it. Now, Florian says that the FTC can't show that Call of Duty is a critical input for cloud gaming. It's impossible to argue that the competitive process would be seriously jeopardized by a hypothetical foreclosure. But that is what Judge Corley told the FTC yesterday. It had to show this. She wanted to know how the consumers would be harmed. She also said, how does this not benefit consumers having more access to Call of Duty? Once again, Nvidia would have access to it. Nintendo would have access to it. She went even deeper. She said 62% of PlayStation players don't play Call of Duty. She said the remaining players that do play it for like 5 hours, and then they never play it again. Or some of them clear it and never play it again. We also saw that 1 million consumers on PlayStation only play Call of Duty. And when they're not playing that game, they don't turn on their PlayStation. And the FTC is trying to argue that those people, that 1 million users, would migrate over to the Xbox. And I don't think they would. And once again, Call of Duty is going to be on the PlayStation. Microsoft has offered them a contract. And the judge asked, hey, if this deal was signed between Microsoft and PlayStation for Call of Duty to be on their platform, would we be even here? And the FTC kind of danced around that question. It's a simple question. Answer her. And he's like, well, but we would probably still investigate it. She's like, okay, fair enough. Of course you would investigate it. But would you still be here? I think we'd still be here because we'd have some other concerns. So we'd be digging up some other reasons to bring them here. Yet, in court, your main objective is to make sure that Call of Duty is on the PlayStation, and you don't believe that Microsoft is going to do it. You're questioning their judgment. You're basically saying that they're lying on stand, that they're lying under oath, that they're lying to the judge. You're trying to say that, yeah, there's some contracts there, but we don't know what's going to happen in the future. There could be little small stuff written there that they could just take some of this stuff and renege on all of the things that they said. And the judge was like, hey, Nintendo is a big company. They know what they're doing, and they signed this deal. Nvidia is a $1 trillion company, and they signed this deal. And she asked, why would they sign this deal if they didn't like it? Because he was trying to say that Nvidia didn't like it. And Microsoft basically sweetened up the deal for them, so they signed it. And Microsoft's lawyer said it doesn't matter if we gave them extra stuff, if we sweeten up stuff for them. We gave them things that they wanted in the past, and we came to an agreement. This is going through now. This is now available for more consumers. If your concern was that consumers are not going to have access to Call of Duty, that was addressed because more consumers are going to have access to Call of Duty after this deal goes through. And the judge pointed that out. So how can this be anti-competitive? So you understand what I'm saying. They have to prove that this deal will harm consumers, and they're not. The evidence is actually the opposite to that. It's going to be better for consumers. It's going to be better for competition because cloud providers are going to have access to this game that wouldn't have access otherwise, just like the consumers. And this was made abundantly clear by the questions that the judge was asking the FTC. She wasn't really asking Microsoft's lawyers a lot, like, prove to me this, prove to me that. She was basically saying to the FTC, let me see your numbers. How did you come to that conclusion? How did you come to that 20%? Jim Ryan? No. How did he get that 20% number? What was his calculations? Where did he get his numbers from? Oh, he was looking at the PlayStation 4 and the Xbox One, which has nothing to do with the Series X and S and PlayStation 5. That was a different market. And once again, you have to remember that Microsoft has offered Call of Duty on the PlayStation multiple times, and the judge knows this. The CMA is trying to delay their hearing. If you're so confident and you have all the information, you've had a lot of time to prepare for this case, you want to delay it till October because you know that Microsoft has to close this deal as soon as possible. And I'm glad that the ruling in the UK went down and that they will have to present their case on the 28th of July. What does this mean for Microsoft if they win this case? They can close the deal. Now, we're going to get into all of those details here. Now, he says there's no smoking gun. It's safe to say after 5 days of hearing that the FTC has not found a smoking gun among millions of documents. An email which a mid-level manager talks about a mere possibility of spending Sony out of business is not impressive. He goes on to talk about the recent developments in the UK and Canada. During the hearing yesterday, I tweeted about a decision made by the Competition Appeal Tribunal in the UK denying a stalling motion by the CMA, as well as a letter from the Canadian Competition Bureau to Microsoft's lawyers in the FTC case, requesting that the letter be, as it indeed was, filed with the district court. So we went through that letter again. We're not going to go through all of that. Now, he says, I personally have no idea whether any of the decision makers share the same view in the slightest, but I believe that the CMA's renewed attempt to stall, which is contrary to the clear directions from the UK Prime Minister that the regulatory process should not hold up business, weighs in favor of closing over the UK regulator after the FTC has been defeated in court. So like I said, it's going to give Microsoft a lot more leverage when they win in court. And I think that's when you're going to see the CMA cave. I don't think they're going to want to be embarrassed like the FTC. And the FTC is a much bigger regulator. So if they get embarrassed like this, imagine what's going to happen to the CMA. Now, the Canadian letter is just an expression of solidarity by one regulator with another, especially between regulators of neighboring countries. So I think Canada and the UK, I think they made the call. CMA said, hey man, send this document to the court because you guys said that there's going to be some problems with this deal, so let the judge know. But it has no bearing on the case. First of all, the FTC is saying they just want to rule about the US. So why are you bringing in Canada? Also, Canada's deadline to block the deal is over. It passed. So I don't understand why you're even saying anything. You had an opportunity to speak on this and you chose not to. And I know I'm Canadian, so don't take it out on me. I didn't make the decision. I think this deal should go through. Let that be noted for the record. In all seriousness, I do believe we're close to wrapping this whole thing up. I think the judge early next week will rule in Microsoft's favor. Now, we're just going to go over to The Verge. Tom Warren, he actually did a write-up. Let me see if I can find it here. Judge Corley will now make a decision and issue an order in the coming days. Some of the legal arguments still need to be filed on Friday and some other administrative parts on Monday. So it's likely that we won't hear a final decision until Monday at the very earliest. With the 4th of July holiday in the US, that will probably push the result into Wednesday next week, though it will almost certainly come before the end of the week. If the judge grants the FTC's preliminary injunction, the deal is almost certainly over for Microsoft, unless it's willing to renegotiate with Activision Blizzard and then attempt to navigate months or even years of the FTC's administration case against the merger. And I don't think that's going to happen. Microsoft, they said that they'd walk away pretty much from the deal if this doesn't go through. And Activision said the same. So they'd have to pay $3 billion if this preliminary injunction is granted to the FTC. Now, if Microsoft wins, the FTC will likely have a week to appeal, but the regulator often decides not to go after an appeal after a loss like this, paving the way for Microsoft to close its acquisition. And then, of course, we're going to have to deal with the UK, the CMA, and all of that stuff. Now, my knowledge is that after the judge comes with its ruling, if it's in favor of Microsoft, there's a 5-day cool-down period of the temporary block, and then they can close the deal. And I think they would rush to close that deal before the FTC could even file an appeal. And it's most likely that the FTC won't file an appeal. Now, they can continue to sue Microsoft in their court hearing in August, and maybe impose some fines after the merger is completed. I pretty much think that the judge's ruling is going to end this case once and for all for both sides. If it's ruled in the FTC's favor, I don't think Microsoft is going to try to negotiate with Activision and extend the terms of this deal. And if Microsoft wins, I don't think the FTC is going to appeal, and I don't think they're going to continue on with their hearing in August. I think that'll give Microsoft a lot more leverage over the UK, and I think they'll be able to come to some type of agreement. So to all the people that are saying that the FTC won or they're unsure whether Microsoft won or not, you can see by the questions that the judge was asking the FTC. The FTC failed to answer the judge's questions. They couldn't come up with a method and how they achieved that 20%. And when you looked at all of the paperwork in the documents, it was actually a 5% market shift. And this is all hypothetical. Microsoft has sworn under oath that Call of Duty will be on the PlayStation for many years to come, up to 10 years, even on their next generation console. And I'll say this, a key thing what Judge Corley said to the FTC was this: you guys won. You got them to do what you wanted them to do. This is now available to more consumers. The FTC said, no, I don't want to say that we won because we don't know what they're going to do in the future. And once again, the judge was saying Nintendo, Nvidia, they signed these contracts. They're big companies. They know what they're doing. So even though he said that, she already addressed that issue. And when she's kind of patronizing them, saying, hey, you did a good job. You did one for the consumers. Because of your pressure, this is now going to be available on more platforms, which is good for consumers. And that tells me that she's going to rule for Microsoft. Anyways, I want to know what you guys think about all of this. Yes, it was a surprise video. I think this will probably be it until the final ruling comes in. I want to know what you guys think, so just let me know in the comment section down below. Were you happy with my coverage? Do you think that the FTC proved its case, or do you think that Microsoft is going to have the approval to close this deal? Let me know in the comment section down below, and like I usually say, please like, share, and subscribe to the channel, and I'll see you guys on the next one.